over to you, Maggie.
Thank you. And you've just seen the notification flash up that the meeting is being recorded. We will be uploading this to our website, www.dgunlimited.com, so it acts as a learning resource into the future. So welcome everyone. I'm very pleased to see you here this morning. Tabby, who you've already met, our creative producer, is managing the webinar today, whilst our colleague Katie is taking a very well-earned staycation. All mics will continue to be muted throughout the presentation. This is because we get, as you've heard, when there's multiple mics, we can get a lot of interference with the sound quality. Tabby will also manage the chat, so the chat can be accessed from the bottom tab in your screen. We would like you to think, if you think of any questions through the presentation, which we're sure you will, if you can just put those into the chat, and at the end of Philip's presentation, Tabby will put the questions to Philip, and we can then have a bit of a discussion after that. So, welcome to our 7th, can't believe that already, 7th Next Level webinar. This forms part of our wider activities which connect, support and promote the region's creative sector and the communities across the region. DGU has a very strong vision which is framed in our document Distill, which again you can access on the website, but that vision is to make Dumfries and Galloway the destination place where artists want to come, live, work and make a living. Here, just quickly to let you know that the image that we have in this slide, it's from Stuart McPherson, who is a music sound artist. This is taken from Solway to Svalbard, which is a collaborative and creative response to the migration of barnacle geese. We have supported Stuart through our ICC fund. He was also the recipient of a significant Bright Sparks Award, and that's what he's used to support narrative character development. And this is a new departure from him from just music, and he also partnered with National Theatre of Scotland and worked with a dramaturg, Davy Anderson. So that's just one example of the kind of support that DGU offers to our creative practitioners. So our Next Level series of webinars is part of Creatives Unlimited, and it's a one-year programme based around 3 key strands: growing leaders, growing ambition and growing visibility. And yet again, you can see there's a pattern here. I'm referencing you back to our website where you can get full information of that on the Creatives Unlimited tab, and there's also links there to other webinars that we'll be running in the future. We are a Scottish charitable incorporated organisation, and we are very grateful to our funders, specifically for Creatives Unlimited, Creative Scotland through Big Lottery funding, the Hollywood Trust, who are funding the youth element of Creatives Unlimited, and also the D&G Council, who help fund our ICC awards, and also we have a service level agreement to help support and be a voice for creative sector and communicate with council. So moving on to our guest speaker today, Philip Hannay of Clough Solicitors. Philip is an incredibly energetic and passionate, did I hear him laugh? Passionate, multiple award-winning UK corporate lawyer and IP litigator. Sounds scary, doesn't it? Regulated by Law Society of Scotland. He has over 55 years, wearing very well, I hear you say, but that's 55 years of combined board experience through executive, non-executive roles, which includes being a member of Scottish Government's Creative Industries Advisory Board. He's also becoming an expert on how to manage sleep deprivation as a parent of a 6-month-old. So he is going to be bright and bushy-tailed though today, and I just think it's worth adding that he's the first Scottish firm listed on the UK Intellectual Property Office's list of mediators. This is a subject for us creatives that is really important. Our creativity, it's very much bound up with us and who we are, but also how we sustain our practice and try to make a living. So really looking forward to hearing what Philip has to say today. So thank you, and take it away, Philip.
Great. Well, thanks for that introduction. I was actually wondering, who is this that you're talking about, because I've forgotten about all that marketing blurb. But true story, when I was applying to see what I would do with my life and study at university, I had an application for art school and an application for law school. I put them behind my back, told my mum to pick a hand. So the reason I am here as a lawyer is down to my mum. It's just coincidence. Otherwise, I could have been hopefully an artist. And that's what I think drew me to intellectual property and copyright law. I don't usually say that, but I'll just share that with you today. And that is, I've got an interest in it. Perhaps I wasn't that talented as an artist, so perhaps it's a good thing that I'm here as a lawyer. But I'm interested in your creative practice, and I would be interested to know what type of creative practice you're involved in. So if you're able to put it in the chat function, Tabby can feed that back to me later on. So if you're a photographer, if you're a fine artist, if you're a sculptor, it'd be good to know that, because in terms of the copyright, it'd be particularly helpful in terms of just steering where to go with the conversation, and also how to address your questions. Because it may be that some of you contract with each other to borrow on the expertise, the creative expertise, and that might raise some issues which we need to address in the Q&A later on. So speaking of a Q&A, if you do have any questions, bang it in the chat function. Tabby can stop me and say, there's a fantastic burning question here. Somebody needs to get away in 5 minutes. Can you just answer this off the cuff? And I'll go for it. Otherwise, we can save them up and we can have that in half an hour or 45 minutes just at the end of the talk. I have been invited to speak about copyright law as it applies to creative practitioners. And just before I touch and launch into that, and if I'm speaking too fast, tell me to slow down, or if you can't understand my accent, or if I'm too far away from the camera, just let me know and I'll try and accommodate what your needs are. Because the most important thing for me is you take away some value today. Maybe it's a new bit of knowledge, maybe it's a little steer in terms of best practice for dealing with your own copyright, or whatever. Maybe it's entertainment, I don't know, but hopefully you take some value away today. Well, copyright, where does that, how does that interact with a lawyer? I did say that from a personal point of view, obviously I've got an interest in the arts and therefore I gravitate towards that. But why are lawyers involved in intellectual property, just as a brief introduction? Because intellectual property, the academics, they fight over it. What does it mean, okay? And there's books and books. I did a little video clip of all the books here. I have a book wholly upon the debates around what does intellectual property mean. And if you were to ask me, it's just the output, okay, of the mind, okay? So if your mind's thinking about something, the conclusion, the output of that process, that's your intellectual property. Let's just have that as a definition for IP, as they sometimes call it, okay? And society has a fantastic interest in that intellectual property, your creativity, whatever practice area you may be in. Because for two prime functions, and this is relevant when we get down to the granular level of copyright. First of all, your creativity can have an impact in industry, okay? The economy, and that's, we're in an election year in the US, and the economy's on the newspapers every day these days, particularly how do we get back from this? Is that V-shaped recovery? Is it a Y? Who knows? Somebody says that a Y shape with an O. I said, that's a yo recovery. But how do we get back out this recovery? Well, it's the economy, and your creativity will drive the economy, okay? So if you have the output of your intellectual property can have an application in industry, it has an economic function, and it's worth bearing that in mind. Secondly, that was the first thing, it has an economic function. The second thing is, it's about reputation. So if you're a creative person, you're creating things, you're going to generate a reputation. Okay? And it's extremely important for you to understand that your intellectual property can have an economic relationship with the industry, but it can have this reputational aspect for you in your career, in your practice, okay? And so because of these two great things, it stimulates and it gets industry going and it generates a reputation. And particularly from the reputational side, it could be a reputation because you're explaining things, you're showing things that people didn't know before. Maybe you're writing a book. Maybe you're an author and you're writing a book on the meaning of life. Maybe your art is showing as an insight into daily life that people, industrial photography, for example, or people who document industrial photography, people forget to look at the art in the everyday. And just reminding people about that makes us more human. Well, that's not about economy, and that's not about industry. That's more about, that's about the big questions of life, humanity and reputation, that two things. So if we just start by thinking about the interest that society has in the intellectual property stimulating the economy and the generation of reputation for those who do the creative work, then clearly there are going to be areas for disputes. Because if people see people getting a reputation, people will try and copy what they're doing so that they can get a reputation, green-eyed envy, etc. Or if somebody's making money from some particular creative endeavor, then you bet your last bottom dollar that somebody's going to say, if they're making money from doing that, I'm going to make money from doing that. And then we get into all sorts of disputes. And so because there's the potential for disputes, or because there's a need, because of the importance of these two functions for society itself, the elected officials, let's just call them politicians, have stepped in and they have created laws. And therefore, there is the interest for lawyers in the creative output of your mind. Okay, so that's the introduction. Okay, questions coming in here. Okay, good. Thank you, sir. Okay, thank you for the introduction. That's a good start. Right, so there is these two things, and in the domain of what has the government produced then? What's the government done for me as an artist in relation to my intellectual property? Well, they produced effectively, let's say, 5 key areas, and I won't go into these in detail because it's not the remit today, but there's 5, let's just call them spotlights, which shine upon your creativity. I'm not saying there won't be shadow areas. I'm not saying that the laws and the lawyers and the politicians have covered everything, but there's 5 key spotlights which have been produced to give you some insight, to give you an understanding around how the law sees and regulates your intellectual property. The first of these is patents. So if you've got an invention about what something does, then you can apply for a 20-year monopoly, and you'll be the only person who can manufacture or allow somebody to manufacture an item conform to that invention. And hey, the Sunday Times Rich List that was published a couple of weeks ago, the number 1 person in that list, the richest person in the United Kingdom, is Mr. Dyson. What's he all about? He's about invention and patents. So that just shows you how worthwhile thinking about protecting your inventions are. Okay, so that's patents, that's number 1. Second thing is design right. So if you're less about how something works, okay, you're less of a scientist, and you're more about creating the design of something. So it's the appearance of an item, be that something that arises from the lines, the colors, the textures, the materials, the surface decoration, the contours, the configuration, or the shape. If it's anything to do with those items which meet the eye and make it an attractive item, so who cares how it performs? It just looks cool, right? If that's your business, then it's about design right, and there is legislation and there's legal rights that apply to your design to make sure that you can stop people copying your design, okay? So there is patents which apply to how something works. There's design right that applies to how something looks. And then there's trademark law, which applies to really, what's it called? Who owns it? Who made this? Okay, so if those are the questions which are relevant, okay, then it's trademark law that comes in there. And a trademark can be any sign. as long as it's capable of being represented graphically and it can distinguish, here's the function, it can distinguish the goods and services of one trader from another trader. So if you say, hey, I've created a smell, and that smell, right, people will know my business when they smell that smell, okay? Will be good or bad. Then you can trademark a smell these days. And usually when I'm out at the universities and I'm talking to the law students, and they say, Philip, shut up. There's no way that you can recognize a business from a smell. I say, is that right? Well, who's been up the Buchanan galleries lately? Before lockdown, obviously. Then who's been up the Buchanan galleries, and when you come off the first escalator and you go, what do you smell? I just need to say that. And they all go, Hollister, right? And I say, there you go, okay. So you know the shop just because of the smell. You come off the subway in Byres Road in the West End of Glasgow, you go, I can smell an actual shop called Subway. And I can also smell Starbucks, by the way. So they are reaching the consumers by the smell, and they're drawing them in before they even see them. And they're thinking to them, I need to go to Starbucks, I need a pick-me-up, or I'm so hungry, I need to go to Subway. Okay, so the smell of certain things can be a trademark, so can the sound, okay? So can, like, the jingle of a little red phone going over the horizon, okay, direct line, okay? And all these things, they can be trademarked. Colour can be trademarked, like green for petrol station forecourts. If I just say that, you're saying, oh, that's BP. If I'm saying chocolate and purple, you're going Cadbury, right? And so on and so forth. And so if you associate any sign, be it a logo, swoosh, you know, be it a name, be it a number, 3 for telecommunications, or whatever it is, then you can register that as a trademark. And I'll come back to this, I'll touch upon this, because as an artist, your name, your non-deplume, maybe you're using a separate name from your actual name, okay? Maybe you're in an area you don't want to create a persona or whatever, but your name as an artist can be trademarked, and there's a lot of advantages, and I'll come back to those, perhaps we'll talk about this in a bit of depth in Q&A, a lot of advantages in doing that, okay, over copyright. So if it's about how something works, okay, if it's a process or a product and it does something cool and it's absolutely new, then think about patents. If it's about how something looks and it's, man, that's so cool, I better just go and buy that, I don't even know if it works or if it's good or not, then hey, think about design right. If it's about what it's called, so hey, I don't care if that looks horrible, and I don't care if it's duff and it doesn't work, it's got the Apple sign on it, so I'm buying it because I'm loyal to the brand. Hey, you're in the realm of trademarks there, okay? So that's the first 3. Then we're down to the last 2. Okay, the second last one is confidential information, okay? So if you work for somebody, or if you tell somebody, hey, I'm going to tell you something in secret, and the person says, okay, tell me something in secret, or if you mark your folder top secret, confidential, for your eyes only, right? Sounds like a lot of James Bond movies here, right? Well, all those things, you're starting to what we call you're contracting, okay? It's a verbal contract, or it's an implied contract, because you've marked something with a condition and that person's accepted it. So by virtue of contract, you are protecting confidential information, okay? So, no adage in intellectual property law that says there's no legal protection for an idea, okay? Now that's true, but I would argue that there's one exception, and that is you don't tell anybody. You can protect your idea by zipping it and not telling anybody. And there is quite a few examples. There's a great BBC documentary, 5 minutes long, it's on the BBC website, it should be still accessible, called Starlight, about a hairdresser who found a new chemical which had fantastic heat-resistant properties. I won't bore you any longer, it's worth watching though. And he kept it a secret, okay? And he protected his intellectual property that way. So we have the patents, we have the design right, we have the trademarks, we have confidential information, and then the biggie, and the one why, you know, for the rest of the time here, copyright, okay? Copyright. So you might ask me the question right now, what's so good about copyright, okay? Well, the good thing about copyright is it's free, absolutely free. If you came in with an invention, hey, I've been inspired by Mr. Dyson and I want to go and patent this, well, I'll be saying, well, do you know what? You're going to need to engage a patent attorney. We're going to need to articulate all the new things about it and all this. It's going to cost you just off the bat £4,000 to £6,000, etc. to get the expertise to apply for a patent. You're going to need to renew it every year after its 5th year for the remaining of its life. And if you want to secure protection through the whole world, you're going to need to apply to the UK IPO, you're going to need to go to the EU IPO, you're going to need to go to the US IPO, the China IPO, and every other territory you want to cover. And it's going to be roughly £250,000 in order to gain some form of global protection for your invention. That's how expensive patents can be. And that's just protecting it, never mind litigating it. To litigate in the court session in Edinburgh, a patent litigation case, the Scottish Government will tell you it's £750,000 for your lawyers alone. Okay, that's how expensive it can be. But when it comes to copyright, you don't need to apply anywhere. There's no registry. You don't need to fill in a form. Okay, might be different in the USA, but in the UK, when you have expressed your idea some form of way, okay, subject to some qualifications, then you have copyright. It is automatic from the point that the work is created. Okay, so it's free. You can't improve upon it. So there is a level of design right when we're talking about how something looks. There's unregistered design right. You can get that, which is free as well. But generally, the expectation is if you really think your design is going to go somewhere, you then register your design. And there's a cost involved in that. They want you to pump up the legal protection. Okay? But when the copyright comes, it's not, there's no registry, there's no way to better it, okay? It's just free, it's just available from the point the work is expressed, right? So that's the first great thing about copyright. So you might say, well, copyright sounds like the best one, yeah? Well, there is a downside to copyright, okay? Big downside to copyright is because it's so automatic, because it's free, then it just seems to crop up everywhere. It doesn't even crops up when you don't intend it to crop up. And that's a big practical takeaway, which we'll just come to the second, particularly for the Q&A. When you're engaging people, when you forget about copyright, copyright will be a relevant thing, because if anybody is doing any creative work, using their own labour to do that, there's going to be a copyright issue. So make sure you have a contract, make sure you have a letter from somebody, make sure you have something in writing which clarifies the copyright position. Okay, so that's the big plus of copyright, that's the big disadvantage of copyright to some extent. So let's drill into copyright that bit more. Okay, how much time we got left?
You're fine, Phil. You're fine. You're fine.
Okay, let's get.
You've got half an hour. Keep going.
Half an hour, great. Sorry, sweat. Take the top off. They said I'd be energetic, so there we go. I've spent my energy up already. So, right, copyright. Let's say, like, I think a helpful thing would be understand there's 3 groups. Any copyright issue, and I've just invented this during lockdown, but any copyright issue can really be resolved by thinking through 3 groups of people. The first group is the author, okay? And by author, I mean photographer, the creator, the writer, you know, author in that general sense of who created the work, okay? So the first thing is, and I'm sorry if you can't, this is just for me, my own, so I know what I'm actually saying, right? So number 1 is the author. Is that always think through who created this work, or who is going to create this work, who will be creating this work, okay? And that could be not just one person, it could be 2 or more, okay? And we'll come back to why all that's important. So the first is who is creating a work. That's a very important, to me, that's a very important point, because I don't need to teach you the legislation. This isn't a law class. I'm telling you from a practice point of view, think always, keep in mind, who's going to be creating creative work. The second thing is, who is the owner, right? And I don't necessarily mean here who is the owner of the actual thing, okay? Because when we come to in copyright disputes and thinking about how to manage your practice for copyright reasons, this isn't the big thing. The big thing here is who owns the copyright, right? Not who owns the thing. So if I go to, it used to be that I'd go every year, I used to go to the Glasgow School of Art degree show, right? I used to, you know, sob into my hanky, this could have been me. right? But I used to go there and I used to buy a piece of work from a graduate every year to support the cause, okay? And I would go there. I guess I was a little bit of a young pup. I was probably a little bit gung-ho, and I would say to some of the artists, hey, I'm buying that painting, it was one of the big paintings, how much do you want? And tell me the money. I say, oh, no problem, I'll pay you that. Can I get a copyright as well? No. Not that they knew much about copyright, but they were told never give your copyright away. That was a good bit of advice, probably. But I was buying the painting, but the discussion was clear. I was not owning the copyright, right? So there's a difference between the physical thing and the right in the work itself, okay? So owner of the copyright. Who's the author? Who's creating the work? That's the first group to identify. And these aren't necessarily, they aren't mutually exclusive. So the person who's creating the work could be, and we'll come to why, could be the owner of the copyright. But it's just at this stage to think who's creating the work, then who owns the copyright, okay? And the third important group is users, okay? Who is going to be using the work, okay? And think about that. So now that I've put that on the board, and maybe in the Q&A I might need to point to these a bit more, let's just say, well, what types of work can copyright apply to, right? You know, does it apply to absolutely everything? So the answer to that is probably not, okay? So the main groups of work, so if you're in any of these areas, this is so relevant to you. And if you're not in any of these areas, it's worth raising this at the Q&A so we can try and find some value for you to take away today. But the first area is musical works, okay? So if you're creating music, you're an author, you're a creator of music, musical works, be that you're expressing it by jamming, you're just getting in with the groove. I don't know, I'm not a musician. Let's say you're a guitarist, and you're just jamming away in the garage or in the house, and you're coming up with riffs and stuff, okay? And you've just got, the whole time you've got the tape recorder, I don't know what it is now, your phone on record, right? People don't use that tape recorder, but you're jamming away and you're recording it. You are fixing your work has been expressed through the music, and you're fixing it in the recording, okay? And so you have fixed your work. The musical work is in the recording. Therefore, there will be copyright in the musical work, and and it will exist in the sound recording. Now, sound recordings themselves are a work itself in which copyright can exist in. So it's important to try and think through, is somebody, if you're sitting at home and you're jamming and you've just pressed record on a tape deck, then what you're doing is you are fixing your musical work. But if you go into a music studio and you're in and you're jamming, and there's somebody who's sitting there at a massive mixing desk, Tabby has probably got one of these in front of her, but if you've got a massive mixing desk and somebody's using their mental faculties and they're listening to you jamming and they're then controlling the sound, they're doing a creative work there by doing all the different mixing to get the best possible sound recording. Therefore, the person who recorded the sound in that situation, I would argue, is the owner of the sound recording of your musical work, not you. So you've got to have the contract which regulates that. Okay, so that's an example that I was alluding to earlier on about if you're having to get somebody else to help you in your creative practice to watch out for these the copyright little pitfalls that can arise. Just while I'm on this point, another example is, and I know we're in the context of musical copyright here, but if you're take example, if you're a jeweler or a ceramicist and you're creating jugs or you're creating rings, and you say, look, I want to get a new website done, or I'm creating a new website, but I'm going to get a friend who's a photographer to do product shots. And this is very common for the students when it comes to a degree show, because they've got big posters and things and flyers to give out. They'll ask their friend who's a photographer to do the product shots. Now, as we'll come to, a photograph is another type of work in which copyright can exist in, So who is the author of the photograph? It is the photographer. It is not. So the photograph of your jewellery is not owned by you because you own the jewellery. It's owned by the photographer because the photographer is the person who created the photograph. So don't make the error of thinking that the subject matter of the work is that relevant. The law is thinking about the copyright goes to protect the labour in creating the work, not the subject matter. And that's the important thing to think through. So if I am going to get somebody to do even a photograph of me for the website, you know, it used to be the classic one was you got I'm having a wedding, I get a photographer to take pictures of myself from a wedding. Just because I pay the person money to take photographs of my wedding, I don't own the pictures I get given. The photographer does. What I own is I'm a user. So I have paid to become a user of the work that the photographer's taken. So likewise, if you're a ceramicist or if you are a jeweler and you're getting a friend to take photographs of you, the owner of the copyright will be generally, the first instance, it will be the creator, not the user. Okay, the user, even though you pay money, here's another pitfall, even though you pay money, that does not in law signify a transfer of ownership. What that signifies generally, if anything, it signifies you paying for use of the work. If you want the position to be anything other than that, you need a contract, right? And when I say a contract, I don't mean, you know, you go to some lawyer, big massive bit of parchment, quill comes out, oh, that'll be £5,000, blah, blah, blah. Okay, it can be simple as a letter, one paragraph in a letter, you know, dear client, dear customer, dear Bob, dear my friend, I just referred to the job that you asked me to do, you know, in return for, or free grata, or in return for £1, or in return for £50, I transfer the copyright or all the intellectual copyright to the work that I'm creating to you, blah, blah, blah. Something along those lines, right? It just needs to be in English, and it just needs to be clear who is going to own the copyright in the work, okay? Now, the amount of problems that would solve, I know it places a bit of an administrative burden on you, but it is necessary because you will come into problems if you don't document who will own the copyright, okay? So where was I? Yes, so the first big class is musical works, okay? So musical works, if you're a musician, etc., think about that. And hey, if you're working in sound, in broadcasts, and all those things, think about who is making the recording, who's fixing the actual work that's going on here, okay? Who's fixing the creativity, okay? So the second category after musical works are dramatic works, okay? So if you're a dramaturg, if you're adding the flourishes to a screenplay for actual performance, so you are actually giving it breath and life and hey, you know, giving it the reason why people are going to applaud at the end of a show, you know, then you know there is copyright that applies to dramatic works. Okay, so you might come up with a dramatic device for something. You might say, you know, at the end of this, you know, we want this to happen. You know, some form of thing. I can't give an example off the top of my head, but think about if you're in the area of dramatic work, then copyright will apply. It's relevant to your practice, and therefore, as I said, it's important for you to think through these groups, to think through your contracts, and to try and regulate it to the position that you want. Okay. The other two groups, probably the most regular groups I come across. First is, so the third group is literary works. Okay, so if you are writing a poem, if you're writing a book, if you're writing a screenplay, if you're writing code, so if you're a programmer, if you're a software engineer, it doesn't need to be in English, right? It doesn't even need to be in a typical language. It could be in Python or Java or C++ or any of these other computer languages. If you're writing something, it's a literary work, then copyright will apply in relation to that work, okay? So, this is quite an interesting one because how small can a work be in order to be a literary work? So you have a Japanese haiku, 17 syllables, 3 lines long. Yep, copyright applied to that. Will it apply to a title? Well, my personal opinion is no, okay? It won't apply to a title. Why? Because I believe that titles are really the subject matter of trademark law. If you're putting a title on your work, then that is the name by which something is being known and people then sort of associate with you as the author. So trademark law is really there. But if your title is absolutely, you know, there's something to it, like, let's say it's the front page of the Sun and it says, you know, supercalifragilistic Celtic are atrocious, right? As the famous front cover was that day in Inverness Cali beat Celtic hammered them. Then there could be copyright in just a title, just one word like that. But generally speaking, there's no copyright. You wouldn't classify a title as a literary work. Okay. Now this is a hot topic in intellectual property copyright law, and I don't want to waste time on this too much. But it's important to know that it's because the clever cookies of the 5 heads of the big beasts of America, right? The Amazons and the Googles and the Microsofts and the Apples and all that of America, if they thought to themselves, well, if there's no copyright in a few words, then what or no copyright perhaps in a sentence, then what they did is they started extending the links to news articles so long that they gave you the introductory paragraph to a news article. So that what you had was a lot of German publishing houses shelling out money for journalists and reporters to get really high quality news. And then suddenly all these US companies, like if you swipe left, I think it is on your iPhone, you come to Apple News. Now, Apple doesn't employ all the journalists creating those news. What they do is they just go and, I won't say the next word, but they flag, let's just say that word, they flag the stories of all these other publishing houses, and they flag them by a big long title, but nobody's going to sit and read it all. They're just going to skim through and maybe, and they think that Apple's reporting the news. What Apple's doing is containing the link to that other one in a title, so people can think that Apple's then producing the news, etc. And therefore, in Europe, there's a massive EU-US debate going on right now. And there was I think it's Article 13, the EU copyright directive, and all this getting bandied about. And you might have read in the last month, the likes of, I think it's Google, have paid a couple of billion settlement to some of the German publishing houses to recognise that they're in this little danger zone, or as I've paraphrased it for legal students, where words become works. Okay, there is a gap between there's no copyright protection in words. But works. When does a small amount of words become a work? Okay, that's the big difference there, and that's what's happening in the big legal debate, and that's perhaps you understand some of this news that's going on about Google settling. So you have literary copyright, okay, and so you have to think that through, because a lot of time people phone me up, hey, I'm a painter and I'm using somebody's story in my work, right? Well, come to a few checks we need to make, but if you are, hey, you are a user, you're not the owner, and you're not the creator, so there's going to be some issues unless you think some things through. The last set of works, just so hopefully this is all making sense, by the way, because I'm just e-flowing here. The last set of works, it was musical, there was dramatic, there was literary, and then the last one is artistic works, and this is really the biggie. Most of the people I act for, this is the one that applies, because this will apply to works of architecture. So if you're an architect, or if you're creating small buildings, say even out of Lego, right? If you're creating any models, so even if you're working with a train set or something, or animation, okay, then this could be relevant to you. So works of architecture, works of artistic craftsmanship. So if you're high quality, high skilled, haute couture sort of stuff, then you're right in there. But also the big of the biggies is graphic works. So any graphic works, and that will include photographs, charts, plans, sculptures, lithographs, sketches, paintings, drawings, anything like that. all that will be covered by artistic. It'll be an artistic. It'll be a graphic work, which will be an artistic work to which copyright applies. Okay. So now that we've covered, like, so there's a massive spread of works to which copyright will relate to, and the overriding caveat, in order to think, okay, I'm creating a work. Okay, so I'm going to create any one of these works we've talked about. I will be an author because I am creating the work. You can't say I haven't created it. The question becomes, is there then copyright in the work? And the overriding caveat is it original? Now, the law doesn't impose any qualitative threshold for originality, so you don't need to get a professor scratching the beard and puffing the pipe going, but yes, that's brand new, original, etc. You know, if you apply for a patent, there will be a boffin in some office that has to go through years of checking all this stuff to make sure your patent is absolutely new and it's state of the art and all this sort of stuff. But for copyright, that's not what the law is thinking about. As I said, copyright applies, the legal right applies to protecting your labor as a creative person. It does not, and this is one of the biggest pitfalls I come across, or I believe in copyright law, and that is, it is not about how similar works are. Now, works might be similar, and that might be a clue that there's a problem. But if Tabby and Maggie come to visit Glasgow one day, hope well, then we go to George Square, and they say, hey, George Square, there's a City Chambers, lovely building, okay? And they bring out their phones, and let's just say Tabby goes first and takes a picture of the City Chambers, and then Maggie goes second, takes a picture of the City Chambers, and those photographs, because they can be, are absolutely identical. Then what tends to happen is, and even if Tabby and Maggie didn't know that they were both taking each other were taking the same photograph, what tends to happen is one comes across the other one and says, you copied my work. That's not an infringement of copyright, because you've both stood in the spot, you've both used your own, engaged your brain, used your own intellectual thinking, and you've created a work using your own labor, and if they are identical, so be it. So going back to when I said the law generally has that expression, there's no protection in an idea, this is where it tends to be going. As in, watch out, because people can, there is, I mean, I'm not going to go into like conspiracy theory, but there is a general, people pick up signals from the radio and what they read in the newspaper, and people tend to come up with similar ideas. I kid you not. I had a client once, I had a fantastic young client, had a fantastic idea for a business, and then they were sitting about, oh, I don't know if I'm going to do this or that. And the next thing you know, it was the Apprentice was on it, and it was a final, and they aired their business plans to Lord Sugar. And one of them said, oh, this is my idea. And I phoned the guy up and I said, hey, did you protect your trademark, do blah, blah, blah. No, I'm still thinking about it. I said, well, it might be a bit late now because your idea is no longer really that new. It's been broadcast on national TV. So it becomes a case of being first to market. That's from a bit, some of the other talks that have gone on, maybe they focused on that expression. As a business person thinking about monetizing, make money from your creative practice, you've got to be ready, you've got to have a finger on the pulse, you've got to know where the market is, what are they buying, you know, what's on trend if you want to monetize your copyright correctly. And so if somebody else has come up with something similar, that does not necessarily mean that there is a copyright issue. Okay? What you need to be able to establish is, now, and I'm not choosing sides here, but if Maggie was basically standing in George Square looking at what Tabby was doing, and believe me, I've gone around Glasgow, I've got working on a legal walking tour, and whenever I'm taking photographs of buildings, people always stand, what's he doing? Okay, looking up, what's up there? People are very curious. And so if Maggie was looking at Tabby, what's she taking a photograph of? I'm going to take a photograph of that as well. Or if she was standing behind, just zooming in on Tabby's camera, you know, and taking a photograph of Tabby's photograph or something like that, then she didn't exercise her own intellectual thinking. There was no particular, she was copying what Tabby was doing. And that is where you get into the realms of that's an infringement of the copyright. Why? Because copyright, what's the good thing about copyright? Well, it's free and all that, we talked about that. But the other good thing about copyright, what does it actually do? Well, it's worth outlining this because it's a complicated matter. Copyright restricts, it's a legal right to prohibit 6 different things. And the big one, which everybody tends to go to, is it stops reproduction of a work without permission. So if somebody is going to reproduce, and it's not even, it doesn't need to be the whole of your work. What the law is concerned about has a substantial part, and that's where all the disputes arise in, but has a substantial part of your work being replicated without your permission. And by replicated, we mean copied, right? So if somebody's copied a substantial part of your work, now substantial part doesn't mean 90%, it doesn't mean a majority. It can be 5%, it could be 2%. So, you know, and going back to music again, you know, all the rap artists in the 80s and 90s, oh yeah, James Brown, fantastic, you know, created all this fantastic funky music. We're just going to sample that. It's only a couple of seconds, you won't mind, right? Well, right, sampling even a couple of seconds could be an infringement of the copyright in the work because substantial part. Or if you're taking the twist in a plot, so if you're going to say, I'm going to have this movie, but the end of it is going to be one of the characters who's just sitting telling the cop a load of porky pies, and as he limps off into his distance, his limp disappears, and he was the one, right? Right? You don't need to watch The Usual Suspects to know that that's where we're going with it. So if you take the plot twist, if you take what I would call the intellectual thesis, the character of the work, then that could constitute a substantial part, and therefore, if you have used that without permission from the person you've copied it from, there could be a copyright issue. Just quickly, the other 5 are things like, so if you exhibit a work in public without permission. So if I take Maggie's creative work and she's kept it private, why she kept it private? Maybe she's got a little gallery and she charges a fee for entrance. But even if I buy the work from Maggie, if I then go and put it in a public space, or if I buy a reproduction of the work from Maggie and I put it in a public place without her permission, I have technically infringed her rights, okay, her copyright. And the Scandinavian countries and the Scottish Artists Union are working with this, bringing in an awareness of an exhibition right for creative people. Therefore, there should be an additional fee if you're going to exhibit a creative work in public, because it's a right which is restricted by the copyright in the work. So it's not always just about reproducing the work. It can be about exhibiting in public. It could be about issuing copies to the public. It could be about lending and renting the work. It could be about adapting the work. And it could be about communicating and broadcasting the work to a new public. Effectively, anything which you could charge a fee for. So it's all those economic rights we talked about. The economic use, the industrial use of your creative work. These things are all restrained by copyright. And so they should pay you a fee. They should get a license if they want to use work. Where are we with time? I'm just checking.
You've just got about 5 minutes.
Good, right. Okay, so that's 5 minutes before the Q&A, not 5 minutes in total. Right, good.
No,
right,
5 minutes before the Q&A.
Right, good, good. So the there was a here. So you have these acts which copyright restricts, and if you've used your own intellectual creation, you've used your own independent skill and labour to create this work, okay, unless you are employed by somebody, and unless you've signed a contract to the contrary, you will be the owner of the copyright in the work that you create. Okay? So if you're employed by somebody, well, go to your employment contract. The general default is an employer owns an employee's work. Okay, you could sign a term and say to, I want to own all my copyright. But so who's the author? who owns the copyright. They've got the right to restrict certain acts, but they've got the ability to deal with that right. Okay, so if you upload your work to Facebook, or Instagram, or Twitter, or any of these things, there are terms and conditions of use that apply to each of these platforms, and within the terms and conditions of use for these platforms, there will be a license clause, which is effectively about what use can these platforms make of your work. And if you read the terms and conditions, they are they're so wide. They're so wide. So if you need to use these platforms to raise your profile, to market your practice, then be aware of these terms, because if you grant a license to use your work to Facebook, and in that license it says that Facebook and any of the users of Facebook can use your work for anything effectively, then you're going to have a problem if a user of Facebook then uses your work and then you've got a complaint about it, because they can track it back to say, well, you uploaded it to Facebook, you granted the right to Facebook and all Facebook users to use your work, blah, blah, blah. So be aware of the parameters of the rights that you're granting. You might not have thought about that before, but it's worth thinking about it. And if you are going to be using these platforms, then the practical tip that I would suggest is use a lower quality of the image, for example, or watermark it. So that if you see, so for a number of reasons, for example, if somebody says to you, I got this from your Facebook page, and the terms of Facebook say I can do whatever I want with it, you can then say no, because the image that you're using is not the image I put on Facebook, because the image I put on Facebook had a watermark and this one didn't, or the image I put on Facebook was of so low quality, if you were to blow it up and put it in the front cover of this magazine, or on this tote bag, or this t-shirt, or whatever like that, it would be grainy. But the one that you've got, high quality image, therefore you've taken it from some other place to which I didn't grant the license that I granted to Facebook and Facebook users. Okay? So there's a way to think through managing these rights, okay? And it's about understanding not only your consent to people to use your work, but also if you're importing, I need to touch upon this, if you're importing anybody else's work, dealing with somebody else's creative work. Now, I called up a creative agency not so long ago. They were working on food and drink labels, and one of their clients was, for whatever reason, was asking them to sign a document transferring ownership of the copyright in the labels to the company. Maybe the company was going to be, it's a whiskey company in this case, maybe it was going to be selling the business on or whatever. But it was starting to get its house in order, and it was asking the creative agency who produced a label that was put on a whiskey bottle that went worldwide, etc. But we need you to now transfer the copyright to us. And what they started off by saying was, for nothing, because we've paid you for the work. Now, if the creative agency have all the rights in the world to turn around and say, you paid me to do the job, to do this thing, to get the label, you did not pay me to get the copyright. And so you need to pay me an extra fee for the copyright. Now there's no right and wrong, that's a matter of negotiation. Whether you want to say, well, the copyright's part of the job, I want to be reasonable, might get more work in the future if I give that away. Or if you say, hang on a minute, I'm going to charge more money because as soon as I transfer it to them, I'll never hear from them again. Okay, but that's a different question. The question, what was interesting in this case, was they asked me to have a look at the document that was going to transfer the rights across. And one of the things in that document was that they were granting a warranty that they owned all the intellectual property in the work, and it wouldn't infringe any third party's intellectual property rights. That's quite a standard factual statement that buyers will ask sellers to give, okay? That you own the thing that they're buying from you, and there won't be any problems when they go to use it, okay? And when I asked them a few questions like, did you create everything on this label? one of the things they said was, no, one of the little motifs, one of the little things we got from a stock website. I said, oh, tell me more about that. They said, well, we paid, it's a stock website, there's a couple of graphics, and we just got, you know, it was like 10 quid, 15 quid, and we took that. I said, well, show me the website. So we looked at the website, and then the terms and conditions of that website that said, hey, you can pay us a small fee and you can use any of this stuff. The actual terms and conditions of use of that third-party intellectual property said, yeah, if you pay us a fee, you can use this for commercial purposes. And sometimes it doesn't say commercial purposes, and I've seen cases where people run foul of that. When it says free use, if you read the terms and conditions, it might say free use but not commercial purposes, and therefore you run a problem if you use it for commercial purposes. But in this case, it was for commercial purposes, limited to 10 or 100,000 units. So I said to the you know, how many bottles of whiskey they sold? If they sold under 100,000 bottles of whiskey, oh, they've sold millions. Right, well, there's a problem. Because if you sign this contract, transferring it to them, even if they pay you or not, they're asking you to make a factual statement that their use of it will not have infringed any third-party intellectual property right. And we now know, by examining the contractual terms, you're in a squeeze here. What you need to do is go, and this is often a delicate matter, but you need to go back to the person that you took their creative work from, and you need to renegotiate better terms, maybe an unlimited usage right, not capped at 100,000 units, right? Or you need to buy it from them, whatever. You need to get better rights in order to give it to your client, even if we water down the terms of the warranty. So if you're going to be making a collage of somebody's pre-existing work, then you need to research, you know, ask permission. You need to maybe buy a license. You need to look at the license terms. You need to examine these things because you are then a user of somebody else's work. Now, two things before I finish. I know the time's probably a bit. Two important things I need to say. First of all, copyright does expire, okay? It expires 70 years after the author's death. Okay, now that's a long time. So Marvin Gaye, long dead, shot by his father, but yet his estate are still suing people and making money, like suing Robin Thicke and Pharrell Williams and all these people. 7 million quid, they were awarded $7 million damages, first instance, because Lord Lines infringed one of the chins. Okay, so you can so think about your will. Who are you leaving your copyright to as a creative practitioner? I don't know if you ever thought about that, but it's worth money. It will be worth money, right? So anyway, 70 years after the author's death, the only exception to that is section 303 of the Copyright Design and Patent Act says there's effectively eternal copyright to Peter Pan, so that all the royalties for Peter Pan go to the Great Ormond Street Hospital for Sick Kids. It's a wonderful thing, so lawyers think something good for once. But you've got this. So if you're using work which is over, say, 150 years old, it's probably in the public domain, and therefore copyright is expired. Therefore, you can do whatever you want with it, right? You don't need to pay anybody, ask permission, etc., etc. Right? So whether it's in copyright or not is a relevant question if it's quite an old work that you're using in your creative practice. The second thing that I wanted to say is, what happens if you can't find the person? So what I get called a lot by, hey, I want to make a documentary about this poem, right? Fantastic poem, but nobody knows who wrote it. Or I found this photograph, but I don't know who the photographer is. Or I don't know who owns the copyright, okay? I found who the photographer is, but he worked for this company that got bought by another company that was dissolved and blah, blah, blah. I cannot find who owns the copyright to ask for permission. Well, in that situation, the work is called an orphan work, okay? And therefore, there is a new scheme that's been set up by the UK government. This was really an idea that came out from the coalition, David Cameron, Nick Clegg, and all that. And that was that you can apply to pay a small fee to the UK government, and they will indemnify you against any issue that then arises. So if you say, I found a work, I believe it's still protected by copyright, I've carried out some searches, but I don't know who owns the copyright to go and deal with them, then the government's saying, well, pay us 50 quid or pay us a fee, whatever it may be, and we will cover you. You then have the security to deal with that work. And the purpose of setting up that government scheme was to then make sure that creative people are not apprehensive about exploiting and using and doing stuff with work which is there, which they want to use to create better stuff, keep society going, to innovate and all that stuff, with, you know, without risk of being sued for copyright infringement. So there are these orphan works. And therefore, we come to the last point, which is probably the one which a lot of people are probably thinking, do I need to put a C in a circle on my work in order for it to be copyrighted? No. As I said at the beginning, copyright is automatic, copyright is free, it applies whether or not you say something in your work. However, wouldn't it be a wise idea to put your name, the C in a circle in Philippani 2000, don't put Philippani, 2020, oh, put Philippani in your work, on your work, is that then shows people who the owner, who the author is, effectively who created the work, but most importantly, says who the owner of the copyright is. So your work won't become an orphan work because you've marked your work that you're the owner of it, right? So the person who's going to make the money out the exploitation of your work is not going to be HMRC through this government scheme. It's going to be you if people want to use your work. And if somebody detaches that little declaration from your work, hey, we're on a total winner, you're on a lottery ticket now, because what they've done is they've intentionally orphaned your work from you when you've put a sign on saying it's my work. And that is what lawyers call, you know, flagrant damages and additional damages. That means when it comes to a court, you know, somebody bangs a hammer and says there's been infringement here, and they say, okay, how much do they need to pay you? That's when we start bringing out the multiple sign, and they say they have done something so egregious, my lord, that we need 20 times the amount to make sure they never do this again. So another economic reason why you want to put the circle on your work. Now, I've spoken too much here. It must be great.
No, you haven't. It's really fascinating. But you asked me to remind you about Bowie bonds.
Oh, right. Okay. So you have this copyright, like any intellectual property, it's got value because people are going to pay you to use your work or to get permission to use your work. And so if you enter into a contract with, if you have a contract with anybody, this is probably the clearest example of where I'm going with this. If somebody says, I want to license your work, I want to put it on my website, your photograph, I want to put it on my website, I want your music to feature an advert, anything like that. If you enter into a license agreement for a period of time, and that says every year you pay me X, or per unit sold you pay me Y, right? You now have a contract which obliges the user to pay you money for your creative work into the future. You can take that contract to the bank, right? You can do stuff with that contract. So if I said, hey, I want to use your image for 10 years on my website, okay, and you say, I want $1,000 a year, and I say, fine, so that's 10 grand, and the benefit to me is I'm spreading that over 10 years instead of paying it now. The cost of £1,000 in 10 years' time is going to be deadly, particularly because of all the quantitative easing that's been going on. It's going to be worth nothing like the 10 grand it is now. So if I spread it into the future as a user, that suits me. But for you, you're saying, hang on a minute, I'm not getting 10 grand now. 10 grand's going to be staged over installments over a 10-year period. But you can take that contract and you can take it to the bank, or you can say to somebody, can you lend me that future money against this contract, against the revenue from the exploitation of my intellectual property? And there will be people wanting to do that deal. And David Bowie, for example, his music, there was all the royalties that would keep coming in, whether it was just general royalties through some blanket license scheme that a coffee shop will apply for or something like that, or whether it was specific ones to use his music for a TV show or a film or an advert or anything like that. He securitized, so he got somebody to lend him the money against the future revenue from his license agreement, and he created what's called Bowie bonds. And I think, you know, they're on for ages. I think the creative community should look more serious about things like that, about trying to get contracts that have that obligation for somebody to pay into the future, and then you can do a deal, if necessary, with somebody to draw down some of that money now.
Thank you, Philip. Gosh, but we do have questions. We've got quite a few questions. So I'm going to start with, and just to remind everybody, the reason your mics are off is just so that everyone can hear properly, because there can be background noise when all the participants' mics are on. However, if you need to have a chat with Philip, we can certainly put your mic on. So first up was Laura. She says, if I upholster little green woodwork stools with my wool pile textile in partnership with a woodworker, each item being slightly different from the other because they're completely handmade, how does copyright work with this scenario? I make the little footstools from scratch using my wood pile textile, recycled wool, and seconds off eBay. Is this under copyright? Upcycled wood, oh sorry, not wool pile, wood pile, right. So she's using and upcycling materials and creating works with a partner.
A complicated one.
Yeah.
Good question. Good question. I mean, I think that there is a, when dealing with product which is on the market, so if I go to a second-hand shop and buy a book, for example, you know, there's a bit of exhaustion of, we call it exhaustion of intellectual property rights. So once the person has legitimately put an item on the market, you know, there is a bit of the law starts to distance themselves about what objection they can take from the treatment of that work, okay, from a copyright perspective. So if you're buying, if I've understood correctly, if you're buying old furniture and you're you're applying a new design, your new fabric to it, then you are creating something new. It's maybe going into the realms of transformative work. You're transforming, creating something new. You're using your creativity. You're using your own independent skill and labour. And the output of that, the question would be, you know, what role did the other person, the collaborator, have? Because there might be an issue of, in terms of copyright, whether you and the collaborator that's worked with you have joint ownership of that, or whether you've been, whether it can be identified about the individual roles that you've played. So you could say, look, I own the design, I own this aspect, and the other person might say, well, hey, I've created the shape, etc., and therefore I own this aspect. It is a bit of a complicated one. I don't think there's going to be anybody barging down your door if, you know, in terms of the original product. So they're saying, hang on a minute, you're now selling something which is mine, because what you're saying is, yeah, I bought off eBay, you've already sold that work, therefore to some extent I can do whatever I want with it.
Okay, that makes sense. And actually buying something off eBay, it's almost like a raw material, isn't it, in that instance? Yeah. Next one is Jane, who is saying, if I'm co-creating with a community group, do I retain copyright as facilitator, or is it shared with the community group? I suppose that goes back to what you said about contracts.
Yes, from my perspective, if you're working with, and this is quite common over the years, I've had a lot of situations like this, if you're working with multiple parties that are inputting into creating something, a theatre performance or something like that, then in terms of, if you're the coordinator or the manager, then it's important for you to get contracts or to be clear with everybody about what rights they have and don't have. There are so many examples of, because it becomes an issue after, the legal problem is always after the event. What do I mean by that? Well, you get the Monty Python guys forever getting sued in the High Court in London because somebody said, hey, see that joke you used in the Spamalot? You know, I gave you that one. Or James Cameron, he gets sued by somebody who says, I told you to make the avatars blue. And so when anybody, when you're in some sort of group think situation and everybody's throwing creative ideas about, you've got to watch in terms of, if you've not got everybody to consent to say this is who's going to own the copyright in the result of this, you can be in the situation where somebody turns up later on and says, I was there, I gave you that idea, yes, you know, you didn't come up with it yourself, therefore you were just, you might have written it down into the actual script, but you were you were my arms effectively, you were just recording what I was saying in that focus group or whatever. Therefore, I never signed a contract, so as author, I'm the first owner of the copyright, I haven't dealt with it, you've now used my idea without my permission, now I'm going to sue you. Okay, so that's why, you know, all these successful works, you know, J.K. Rowling, all these things. Oh, I told you to do something with a little wizard boy. Oh, great. Okay, they always, somebody's chapping the door to try and get some money after the event. And as I said earlier on, all these problems in my mind can be solved through some form of contract. I know it is that, and I've said it before, it's a bit of an extra administration, but the headaches it solves down the line are incredible.
That's fantastic. Thank you so much. Okay, next one, which is actually quite interesting to me because of my radio work as well. This is from Finn, and he says, what, if any, is the essential statement that I should use, for example, all rights reserved, to append any music that I produce and share on SoundCloud?
Well, in terms of uploading to any third-party site, educate yourself on the terms and conditions of that process, because I don't know what SoundCloud's license clause is, but if you read it, you'll then understand what SoundCloud's asking you to give away. So it wouldn't matter even if you marked your work all rights reserved, which is a good thing to do. They would argue, yeah, but our terms and conditions say that these are the terms and conditions that apply. It doesn't matter what you state in your work. If you've consented by uploading your work onto our site, then you're governed by our terms and conditions. So be aware of those terms. But generally speaking, yes, you know, after putting the C in the circle with your name and the date, which signifies like I created this on this date, then all rights reserved is a good thing to say, because you're effectively telling everybody, I'm not giving anything away, okay? Don't assume. Contact me and we can talk about it.
Okay, thank you. You mentioned, and it was fascinating when you were talking about exhibition and the right that there should be payments to artists and creators whose work is exhibited, even if they don't actually own that work. Is that included in online exhibitions? We've been developing an awful lot of different activities because of COVID online. So what would happen if we created, like, there are museums who have been exhibiting artworks online. So does that follow for them as well?
So to me, this is a extremely interesting area, and it really is. I can't applaud the Scottish Artists Union enough for the work that they're doing in this area. It's to do with the Fair Work contract that I'm a wee bit behind on, but I'm trying to help them with, get some form of little bit of steer for artists in terms of saying this is how to educate yourself, asking for more fair pay. Now, the Scottish Artists Union did a survey, it was published in 2017, to show the extent of the Scottish artist community, how low they're paid, and their general appreciation is low about expectation of being paid fairly, etc., etc. It's a heartbreaking report to read. But as a result of that, they're trying to get together, and from a union point of view, to say, we need paid properly for our work. And my interest in that was from that area of, if all the galleries and everybody, they all recognise the reproduction right, that if I want to reproduce your work, I need some form of license to do that. So if I want to put an image of your painting in this catalogue, if I want to put it on a t-shirt and sell it, if I want to do postcards in the shop, the gallery, I need a license to do that. Everybody understands that. But in Scandinavia, they also recognise an additional fee to actually place that work in public. And although that if you turned around to the galleries in Scotland and said, hey, I want to charge an exhibition fee now in addition to any reproduction fee, everybody would laugh you out of town and one might argue that a single artist doesn't have much of a bargaining position, because the gallery would just say, hey, this artist isn't asking for that, I'll just go and stop their work instead. But the Scottish Artists Union are taking this quite clever. They're approaching Creative Scotland and the Scottish Government, and they're saying, if there's any gallery that depends on you for funding to do X, Y, and Z, then we want you to then ask them, what are they doing about an exhibition fee? And they're using the Scottish Government on how I sort of further up the chain in terms of galleries and these folk who still rely on Scottish Government funding to say, we're not allowing you to get away from getting public money when we're being exploited, when our rights aren't properly being recognised and you're being paid for. And it's a long process, but it's happened in Scandinavia. And so it's, you know, they're thinking of this coming in. And I see a lot of merit in that, particularly when you get galleries in London who are making thousands and thousands, millions of pounds out of artists' work, and it isn't flown down correctly to the artists.
Yeah, and I agree with that. Thank you.
Sorry, just sorry, on another point, and just to come back, when you were talking about on the website,
yeah,
away from the actual exhibition fee, which I think is probably more designed about you know, physically accessing, physically positioning in public, there is the additional act which I mentioned about if somebody introduces a work in which copyright applies to a new audience, then that is an additional act in addition to the other ones, which is restricted. And so if you've never consented to your work being placed online, okay, and somebody goes and posts that online, they've now infringed your copy, even if they had a right to reproduce your work and sell it in a shop. If you've never granted the right to them, and you've reserved that right, as was saying, but if you've reserved that right, then if somebody's put it on a website, they've infringed your copyright. And so it's worth making sure that you're clear. Are you giving away that right to introduce it to a new market? Because it may be that if you're saying, look, I only, you know, yes, you can stock this in your shop, or yes, you can sell this in X, Y, and Z, but you know, if you put it online, there could be a whole new market that would come to me for that rather than to you, and therefore you're taking away part of my business. Just one final point there, in terms of why galleries are doing that, there is another hot topic in copyright law called copyright surrogacy, and that is, and it's a kind of naughty area, and it's whereby people who possess the actual artifact, and by artifact I mean the actual thing, rather than so if we're talking about, we're now in the area of the subject matter of the photograph. So earlier on I talked about the law looks at the photograph, not the subject matter of the photograph. That in this area, the people who own the subject matter, such as a museum, who possess it and therefore remove it from public sight, okay, these are artifacts and items to which the copyright has expired. What they do is they then take a photograph of it and they put the photograph out in public, such as in their shop. And therefore, if I see a picture by Titian or, you know, John Knox's picture of the Clock Lighthouse right, in Europe, then and I say, well, that's in Kelvin Grove, you know, that painting's owned by Glasgow Museums, it's in their archives, but it's 100 years old, so if I see it on a website, I must be able to use it, and that's not a problem. No, because by taking it out of public circulation and by putting in a photograph, the galleries are trying to exercise their copyright in the photographs and sue for copyright infringement, which is a massive hot topic, because you're saying that's not what this law was designed for, and you're trying to create a perpetual copyright.
Okay. Ooh, that is a massive topic. Finally, Maggie asked, so you've mentioned that when you put an image onto Facebook, you're almost gifting it. What are the best things to actually put in the titles of the image? Would that be like the name, copyright, the date? What would you suggest that creatives put on the images of their work before they put them online?
That's a good question. I don't have really the best suggestion, because some people have said that if I put a watermark on my image, then people might not deal with me because it disturbs the integrity of the actual work. I think that from my point of view, the upshot is understand the terms and conditions of what you're granting to these platforms. Be clear about that, about how wide that is, and think through those practical steps I said about lower quality images, and maybe saying to people higher quality images are available on request, or you can contact me at this email address. But the other important thing is just about making sure that where your work is being posted and reposted, etc., that your name is being associated with it. Now, this might take me just a few minutes to explain, but this is important.
Okay.
At the very beginning of the talk, I talked about the economic rights and the reputational rights. And with any copyright work, there are two, it's like railway tracks, there's two tandem rights. The first is the economic right. Well, when I say this, I mean copyright. But every copyright work has another right that goes up in tandem, and that's called the moral rights. Now, moral rights are only ever owned by the, well, say this generally, they're only ever owned by the author, the creator. The person who owns the copyright, if I'm Universal and I've bought from the musician the copyright so that I can press CDs and make money from putting music on the radio, right? I still don't own the moral rights, because the moral rights always are with the creator, the band, the musician, the writer, the photographer, the artist, the creator, the ceramist, etc. And those moral rights include the big E, which is the right of attribution, the right to be known as the author and the creator. Secondly, the right to object to derogatory treatment of the work, right? Thirdly, the right to object to false attribution. And fourthly, the right of privacy in a work. Okay, so I don't have enough time to go into real life examples of these, but these are extremely important morals. So as a creator, if I'm creating creative work, I might sell my copyright. I might decide that. Somebody might say to me, I want to buy the copyright, and I might say, fine. But there's the second issue of, even if I say, here, you have the copyright, and you can then monetize, or you can recreate, and you can put, copies of it in public and put it on websites and do whatever you want, that's fine. You're paying me money to do that. But what we also need to address is, because I created that work, I am the creator, the author, and I have inherent, as the French would say, inalienable, they don't say it like that, but inalienable spiritual rights, because I am the creator of that work. And you need to also regulate those. They can either be asserted, and if they're asserted, then there's a legal obligation, no matter for anybody who uses that work, to respect the moral rights. Or they can be waived, and that means nobody ever needs to take care or cognizance of the moral rights. Normally in a contract, I would say about 99.9% of the contracts I ever draft, we put in a clause which says the artist, the creator, waives their moral rights. Okay? And so what that means is, if I commission you to paint a picture of my mother, or produce a jug or vase or something like that, we agree a fee, irrespective of who owns the copyright in that situation, I will generally say, look, I want you to waive your moral rights. Because if you don't waive your moral rights, if I place that in public or do X, Y, and Z, I have a legal obligation, if you've asserted your moral rights, to say to everybody, this is who the author was. Or if I replace the handle in the vase with a new handle I've created, I may have mistreated the work. Okay, and so on and so forth. And so I don't want those legal obligations to ask your permission in relation to your moral rights, never mind the ability for me to industrialize your creative work. And so we'll generally ask for somebody to waive their rights. But if you assert your rights, then there is this legal obligation. And the question then becomes, how does one then assert their moral rights in relation to their work? Well, if you're a painter, sign the work, put it in the back of the canvas. You know, if you're an architect, put your name on a brick and shove it in the building, okay? Or generally, if you've got a website and you're putting images of your work there, just put your name with the C in the circle next to the work. Effectively, if you've made a conscious effort to place your name as the creator, the author, next to your work, or if you're asserted your moral rights, then what's interesting is even if you deal with Facebook and all these platforms, and under the terms and conditions it says, hey, you grant them a license to reproduce it and all that, that's all related generally to copyright. It does not then mean that if some clever clogs comes on and right clicks on your image and save, and I'm going to now place that up on my website, and if you ever come to me and say, you've used my image on your website without my permission, and I say, yeah, but I got it from Facebook or Instagram, according to the terms and conditions of those websites, you agreed to grant me a license so I can do that, you can then turn around and say, yeah, but when I uploaded that, it's on my page, or when you came onto my website, my name was next to it, therefore I've asserted my moral rights, and therefore when it appeared in your website, it didn't say the photograph was by me, it didn't say the painting was by me, it didn't cite me as the author of that work, and therefore I'm suing you for infringement of moral rights, never mind copyright.
Philip, honestly, everybody's fascinated because while you're talking, we've got another couple of questions. So the first thing I want to do is ask, is it okay if we just go on for another 5 minutes? Are you happy with that? All right, so Laura is, and actually I find this quite interesting as well, because it's the same if I record someone for a podcast or if someone paints a portrait. She's asking if she turns an image of a customer into a wool textile, who owns the copyright of the textile? Now, having heard what you said, I would have said she does.
When we say an image of our customer, do we mean a resemblance of the person, or do we mean an actual photograph?
No, an artistic interpretation of that person that she created using wool.
So you're saying that the person who's posing the question is saying, I have created a work which there is an image or a resemblance of a person.
Like a portrait. Like a portrait. Yeah.
That's a tricky one. Why is that a tricky one? Well, there's a classic situation that rises quite commonly where, say, somebody, they're in a yachting magazine and they see a picture of a yacht, and then they get their paints out and they're looking at the yachting picture, the photograph in the yacht magazine, and they paint a picture of a yacht, right? And they say, oh, I'm going to sell that picture. Well, in that instance, there is an argument to say that your painting of the yacht is a copy of the photograph that was in the magazine. Therefore, the photographer, and I assume it, the photographer still was owning it, he didn't sell it to the magazine, but the photographer could sue you for copyright infringement. If you are relying, so if you're creating a pillow and it's textile and it's based upon somebody else's creative work and not the person themselves, then it's a derivative work, I would say, and I would the starting point to say it smells like there might be a copyright issue.
Yeah.
Mm-hmm.
Yeah.
Maggie, did you want to say something?
No, I'm just looking at the rest of Laura's question, and she does say it's their own translated work, but their creative work, but translated into textiles.
Well, one of the 6 different acts which that copyright restricts, the last one I mentioned was adaptation. So if the owner who owns the copyright says, yeah, you've just adapted it, and by adapting it, we talk about 2 and 3D translation. So hey, a classic one is, hey, I draw a 2D cartoon character and then you make a 3-dimensional toy out of it. That is, trans-dimension doesn't get out of copyright infringement. Yeah. It's still an infringement because you've reproduced from 2 dimension to 3 dimension my character.
Yeah.
So it's whether you've used your own skill. Well, I guess a derivative work probably is unoriginal because you're slavishly copied from the original work. But there are instances where your work is so transformative, you've created and you've expelled creativity in creating the subsequent work, that is an original work, and you have copyright in relation to that. But inherent within it, there may be a residual part of the original work, and therefore there's still the necessity of having a license or something like that. So whenever you're working, if you're trying to transform a pre-existing creative work, what I'm trying to say is there could be the conclusion that it's not original, and therefore there's going to be a big problem, or it is original, therefore it's your work, but there might and there might not be a need to deal with the previous person. Okay.
Okay. How do you check if you can trademark a name? So, for example, for my radio show, I'm called Totally Tabby, and I've done it as one word, so it's like a logo. So how do I check whether that's available for me to trademark?
Well, so the first place, there's a whole discussion in itself about doing pre-clearance searches for trademarks, but generally speaking, first place to go to is the United Kingdom or Intellectual Property Office on the uk.gov website, and you can conduct a free search, and it's like a wee Google bar thing. You just type in, the mark that you're looking to search for, and you just search all day long to see has anybody registered that. If there's nothing if nobody's registered anything identical or largely similar to it, then hey, it looks like it's free to register as a trademark. But you shouldn't just stop there because there are other people who might be trading and they've never registered their mark as a trademark, and because they've been trading with let's just say an unregistered trademark, they may have the ability to say, I got a problem with that. So you would also want to just do a Google search, checks a couple of good big social media sites. Has anybody using it? Is anybody using it as a hashtag? All these sorts of things. These are sorts of areas, pockets that I would look to just to see, is anybody using it in any sense, to see, and then examine what right might or might not have to object to your application. But the biggie in terms of the first port of call is to go to the trademark registry and conduct the search there.
And then finally, Philip, gosh, you're just being wonderful with us this afternoon. Watermarks, or actually, how do you put a watermark on a recording, on a sound recording? What are the easy ways to do it for images and recordings? Where would they get advice about that?
I mean, I can't answer that. Per industry, there will be people who have come up with quite ingenious ways to watermark. I mean, having a photograph or a graphic can have some metadata attached to it, whereby it's quite clear that unless somebody electronically scrubs it, therefore it's always going to have metadata attached to the file, particularly online. So digital items will always have that ability to carry information which can state this is who they created it, this is who owns the copyright. But in relation to other works, one example I give is anybody who creates a database. So that's another work which copyright and database rights apply to. So if you're creating a table of information, data, then, or if you're doing a playlist, for example, or a recipe book or something like that, you might just throw in one of the recipes or one of the informations within the database. You might say it's Donald Duck, or this one's 10 minutes long when it's not 10 minutes long. So if somebody replicates that list, you create a playlist of tunes and you've said, hey, this David Bowie track's 20 minutes long, and then you see a identical playlist, you say, well, they're not prohibited from creating an identical playlist, but if they then also state David Bowie's track 20 minutes long, you're going, I have seeded an accuracy in my list as a watermark to show I created that. And if somebody has the same playlist and the same mistake, then a court would probably find more than not, and it's on the balance of probabilities, it's not like a criminal case with beyond reasonable doubt. Probably more than not, the person's just ripped off your playlist, and therefore you've got sued for copyright.
Okay. I'm going to say thank you, Philip, and I'm going to pass on to lovely Maggie to close off the webinar. I know that I speak for everyone when I say that that was really interesting. And when we come out of lockdown, we want you to come down here and spend the whole day with us. I don't have to about that.
Brilliant. Thank you so much. Now, I have to do something. I have to credit the photographer of the image which I used for Stuart McPherson's Bright Sparks Award, that being Beth Chalmers' artistic work. So, saying it again, crediting Beth Chalmers for the marvellous photograph that we've used in this presentation. So, and I've been to a presentation of Philip's already, so shows you, you can let some small things slip your mind. Anyway, thank you so much. Thank you, Tabby, for managing the chat, and managing us all, as you do. Thanks to Philip, absolutely amazing. You might not have to go down and lie in a dark room, but so much is the wonderful information overload that I might. But lastly, thank you all for coming along today. As I've said, this will be on the website, and do check it out. Enjoy your afternoon and look forward to seeing you. Keep an eye out on our website for the next webinar. We have a presentation about how to creatively showcase your work from Stuart McPherson. No, not Stuart McPherson. Tabby, rescue me here.
It's Stuart Patterson is doing
Stuart
how
Patterson.
to creatively showcase your work. Stuart Patterson's our Dumfries and Galloway Scots poet. And if you would all very kindly remember to fill in the feedback, we'd very much appreciate it. Thank you, folks. Thanks for joining us.
Thanks again. Bye-bye.
Philip, you stay there for a minute so we can thank you properly. There we go. That was fab. Yeah. Right, I'm just stopping the recording.